This is an interesting story, and it's one where I would think many landlords have been subject to similar. They have inherited a property from their parents. They hadn't thought about what they were going to do when that day came. They hadn't anticipated the property and what comes with it. And adding to that, what do they do? And some try to sell, and others, they don't know exactly what the consequences are. So they approach a letting agent and they rent the property and use the letting agent to do that. And in this particular case, the landlord made the error of implicitly trusting the letting agent. What the agent did was he was negligent in everything. He didn't do the work in this property and let it out to multiple people. So created a house in multiple occupation. So that's where 3 or more people share a property and share facilities such as kitchen and bathing facilities. And those people were living in the house. There was more than 3. And the property, a license had been applied for. So that part had been done correctly. And a license comes with license conditions. And those conditions have to be complied with. And if you haven't represented against them, and in this case, it didn't look like the landlord nor the agent had represented against any of the conditions. So the standard local housing authority conditions were the conditions which they needed to comply with. And as you're probably going to hear in a few moments, they weren't complied with. Taking things another step forward, he appointed the agent, and the agent, having created the house in multiple occupation, didn't follow the management regulations, the requirements under the law. There were many things wrong, not only tenancies, there were issues with the property, there were issues with compliance, the fire safety wasn't correct, hygiene wasn't correct, and there were multiple things that breached the HMO licence, HMO management regulations. And because those license conditions and regulations were breached, when the local authority came to do an inspection, these things were discovered. The idea that a property is licensed makes it compliant is a fallacy. Quite frankly, local housing authorities for a number of years have not inspected properties before granting a license. And because they haven't inspected them, and because they've granted a license, many people assume that that makes the house safe and compliant. That is, in fact, not true. They grant the license, and at some time in the period of the license, they must come and inspect. Many local authorities don't do that early. Some leave it till quite late. It is a legal requirement that they inspect the property. So it's important for tenants to understand that even though it's licensed, are they compliant? One of the simplest ways and the simplest things in compliance is to see that the notice of the manager is on the wall, that who is managing the property and how to contact them. It's the most common offence of management regulations and licence conditions that landlords and letting agents commit. And that's a good start to knowing they're doing something that's compliant, but also the fire safety and making sure the property is safe, the passageways are clear, there's a protected fire escape route, all part and parcel of what is required for a landlord and a letting agent in a HMO. And that's whether it's licensed or required to be licensed or not. So these were breached, along with various other conditions such as the individual rooms, the common parts, their maintenance, etc. So it's very, very important to know what you're doing, and if you are giving it to an agent, you have checked that the agent is competent and qualified. And if you're a landlord looking to select an agent, we provide a letting agent selection service where we vet the agents to know that they're suitable to manage your HMOs and that they understand the requirements. And that is a 50-step process that they have to go through in order to prove that they are capable and able to do the job. So as a landlord, be sure that you're selecting the right agent and that you're not being sold a dream for something they can't deliver. Continuing the story of this agent and the property that the landlord had inherited, he put everything and trusted everything to the agent, and you'd expect that to be the right thing to do. The agent had obviously given him a good story, but the agent wasn't a good agent. The agent had eventually, for some reason, just left the country and neglected all his duties, told nobody about his departure, and to date hasn't been seen for a very long time. I won't go into the exactness of it. And because he hasn't been seen, and because he is a person who is essentially a rogue agent, the consequences is that the landlord who has appointed the agent, you appoint the agent in your name who acts for and on your behalf and in your name. So any failing by the agent is a failing for the landlord as well. Now, I'm not saying all of a sudden don't use agents, because there are thousands and thousands and thousands of reputable agents out there. There are 18,000 agents who are members of Property Mark, or the Association of Residential Letting Agents, ARLA, and they provide training and qualifications for agents, and those who are members are held accountable to the association. So it's important that you select the right agent to do the job correctly. The agent in this case didn't do what he needed to do. Everything was found out by the council when the local housing authority at the council came in to check the property under the licence and the licence that had been granted. And the conditions were, quite frankly, very bad. And things needed to be sorted. The landlord had contacted an agent in the area, and the agent in the area came directly to us because they are a highly reputable agent, compliant, understand regulation, understand what has to happen. But they came to us because he had been enforced against by the council, and they were intending to interview him under a police and criminal evidence interview. That's the same as the interviews you see on the television, where people are interviewed, where there's a recording and you see them. It's not quite as bad as something for the 1970s where there's a lot of aggression, but these are very uncomfortable interviews, and he was invited to one of those interviews, and he sought the advice of our firm because the reputable agent and qualified agent had recommended him to come to us to seek the advice that he needed and to be advised correctly. When the agent had recommended this person to us and we spoke to the landlord was distraught. He wasn't aware of how serious it was, but knew it was very serious and understood that he was in a position where he was going to be interviewed about his involvement in this and his liability and culpability. The hard part and the distressing part for him was when it was explained to him that an agent, as is agency law, acts for and on his behalf and in his name, that he would be as liable for the failings of the agent as he would have been if he had failed himself. This was shattering for him. He just couldn't comprehend how such a thing could be. And that is how a large percentage of landlords who get into trouble find out, because one, they did it themselves, or two, because they relied upon an agent, and you are culpable for the failings of your properties. And the power of the local housing authority is ultimate in this. They are the housing police for the private rented sector. So when they are calling, investigating, writing to you, it's the same as if the policeman came knocking on your door accusing you of a crime, because these matters are, in fact, criminal offences. When one looks at the facts of what happened and that the agent had failed the landlord and failed the tenants and the condition of the property, there was only one thing for the local housing authority to do, and they had to enforce. yes, they had to enforce. Now, there are various parts of the Housing Act 2004 that they could have used. They could have used enforcement under HHSRS or Part 1 of the Housing Act. They also have enforcement powers under Part 2, which is the licensing of houses in multiple occupation. And that is one of the areas which they chose to use, which they can do. They don't have to choose one or the other. They can choose both. They can choose a combination of them. And in this matter, they chose to use licensing conditions and the failure to comply with the license conditions, which both the agent and the landlord were responsible for complying with. The bit that many people don't understand in a HMO license is something that's a condition in that license may not seem like it's a criminal offence in the general world, but once it's in the license as a license condition, and one fails to comply with it, then it is a criminal offence. And the local authority has two ways of dealing with this. They can choose to prosecute in the magistrates' court, which is costly, takes a lot of time and a lot of effort, or in the alternative, if they have evidence at the same criminal level as they would have to prosecute in the magistrates' court, then it's very important that they have it at that level. Then they have the alternative to impose a financial penalty under the Housing Act 2004, which was brought in under the Housing and Planning Act 2016. They can impose a financial penalty, and that financial penalty, although it costs money to enforce, to put it together and to have the evidence, that is far cheaper for the local housing authority to do, and they can recover their costs because the proceeds from the fine are given to the local authority and it goes into an enforcement budget, and that money that goes into the enforcement budget as income can only be used and expended for more enforcement. So as you can see, having an enforcement policy, having a civil penalties regime means that a department can become self-funding and not be a drain on council resources if they use the civil penalties regime. And that is what they decided to do in this particular case. So was the landlord guilty? Absolutely 100%. And because he was guilty, that meant that he had to, quite frankly, admit the crime. But if you admit the crime, you must understand what you're doing, why you're admitting it, and take professional legal advice. Even if you're guilty, the important thing is to make sure that how you go about it is handled correctly. Because many will admit their guilt, but at the same time not realise all the consequences and what they must do when they're admitting their guilt. So why would somebody help the council with their inquiries and go for a police and criminal evidence interview? Well, the reason they do that is very simple, because if you don't help with the investigation, that will be noted and could go against you. Now, if you're completely and utterly innocent, that's no problem. But if you're, say, guilty and you don't want to talk and you don't talk, then the law is such that they insinuate from that and make any interpretation they may wish to make, and that doesn't make it easy for you. So our advice is to seek professional advice and then understand whether you should go to the interview or not. 99% of the time, if there is any culpability, one would probably advise you it's not sensible to go to the interview, because if you do, you're going to incriminate. And if they haven't got the evidence they require in order to do what they need to do, in order to be able to prosecute or to issue that financial penalty, if there isn't sufficient evidence, then frankly, they are not going to be able to prosecute or issue that fine, even though you may be guilty. So it's very important to understand what you're doing, why you're doing it, and the consequences of doing something in a way that you might think is the way to do it because that's how our parents, our teachers and others have told us to, but in fact it's not the right and best way. So the landlord in this situation was guilty. What was interesting was the questions that were asked, and how we got to get to those questions is another matter. What was done and how it was handled was done very, very professionally, and the local housing authority, they issued a financial penalty. They issued the notice of intention to impose a financial penalty. And everybody, when that notice is issued, has a right to make representations. And that's what we did. We made the decision to make representations because that was the legal right. Those representations were prepared based upon the culpability and answering each of the questions that came up from the allegations that were contained within that notice. That notice, you have a period in which to represent. That is legally set out. They can't just impose a fine. They must send a notice of intention, and then you must make representations. You don't have to. If you don't, then they're going to issue a decision based upon what the notice of intention said. But if you make representations, they must give those consideration. And then once they've given them consideration, they can adjust the penalty or withdraw the penalty. And if they decide to adjust the penalty, that's fine. Usually it's lower, maybe because in the representation you've calculated that they haven't followed policy, or they haven't got the information right, or they've got the facts wrong. That's your chance to defend. Some people do that directly themselves, and what we found when we read those many times is that what the person has done is compounded their guilt, compounded the correctness of the allegations, and actually made matters of proof worse, although the fine can't be increased from the intention to the decision. It has to be that or lowered or withdrawn. So in this incident, the landlord was represented. Everything was gone through to answer the questions. But the most important part in this particular one wasn't the fact that the landlord was guilty and that he was going to make representations. The local housing authority, in its calculations, it's very clear that the maximum penalty that can be imposed upon a landlord or a letting agent or anybody involved in the matter who is able to receive a notice of intention to impose a financial penalty, the maximum penalty currently, and this is being recorded on December 2024 for clarity, the maximum penalty is currently £30,000. And the most important part for this landlord is that in their calculations, using their enforcement policy, even though the amount based upon the guilt and the amount based upon the calculations could have been substantially reduced for the landlord, I mean substantially reduced, the most important thing was that the council, the local housing authority, had miscalculated the fine. They miscalculated the fine. When I say miscalculated, they calculated and imposed it above £30,000. And because they'd imposed it above £30,000, this notice was in fact defective. It was in fact invalid. It was in fact wrong. So although the landlord may have been culpable and the agent may have been culpable and not followed due process, the landlord, who was distraught, it was going to destroy him financially, he was very, very pleased and very, very relieved that the financial penalty had to be withdrawn. It had to be withdrawn. Now, the other part of the story I will tell you about is that the agent that came to us originally, the moment the matter came, he was appointed as a new agent, not to manage the property because he didn't want the culpability, but what he did was he was appointed to manage the works, and all the works that were required to be done to the house were done. Coincidentally, along the way, well, because works needed to be done, the tenants were worked with and rehoused in other places, and those tenants now live in other places, and the property eventually, through the works being done, is now fully compliant, but is now vacant. And the local housing authority, not satisfied with having got it wrong, wanted to inspect an empty house, which they're entitled to do, to see if it was compliant with HHSRS. So even though a local housing authority may be wrong, remember they have ultimate powers. And what you will find is even if you've been found guilty of an offence, and even if you've paid a fine, we see more and more often the local housing authorities are revisiting the properties, and in some cases finding nothing wrong, but in others, unfortunately, they're finding that the landlord or the agent or both have done nothing to rectify those things for which they've received fines, and the process starts again. Ultimately, the second time they're likely to prosecute and then apply for a banning order. And quite rightly, enforcement is there for the safety of the tenants. Enforcement is there to improve housing and to enforce the law that is there. The local housing authority is an enforcement authority, not an advisory authority. We must comply with the law. We must do as the law requires. We must comply with our licence conditions. And it's very, very important. Now, to say the landlord is excited, happy, wonderful situation not to have the fine is an understatement. But it is by pure fluke. It is by pure luck. He is still going to sell the house because he doesn't wish to be a landlord. This experience of the criminal justice system in the housing sector has been enough for him. He is going to invest his money from the small proceeds he will now have left from the house because he has spent an awful lot of money making it right. He will now invest in other things that don't involve enforcement action like this. For some landlords and some agents, you're going to want to do the same. If you don't want to do the things that are required, our advice is seek alternative investments. It's been a pleasure speaking about it. It is absolutely wonderful when you win. It doesn't mean the landlord was innocent. Our job isn't to harbour rogue landlords. Our job isn't to harbour rogue agents. Our job is to make sure there's safer housing, to make sure the enforcement is done correctly and safely. And as we know, many local housing authorities are incapable of managing properties themselves, incapable of being a great landlord. Many of them have more hazards and more issues, but that's a different department to the department that deals with the private rented sector. So unfortunately, you can't point the finger. There's no getting angry or mad about it. In the private rented sector, you either comply or you're going to be fined, either in the magistrates' court or by the local housing authority. I wish you luck and thank you very much. Thank you for your time.